we have a case here now out of the District of Columbia, right? District of Columbia Court. And this is the AI case that I was hinting at earlier. So, plaintiff Stephen Thaler owns a computer system he calls the Creativity Machine, which he claims generated a piece of visual art of its own accord. He sought to register the work for a copyright, listing the computer system as the author and explaining that the copyright should transfer to him as the owner of the machine. The Copyright Office denied the application on the grounds that the work lacked human authorship, a prerequisite for a valid copyright to issue, in the view of the Register of Copyrights. Now, this case was decided later last year, after the Copyright Office put out its generative AI notice in the Federal Register. So the Copyright Office had already put out its policy, and now someone who has a AI computer system is suing the Copyright Office and saying that they should be able to have a valid copyright. Not the person, but the system. Plaintiff develops and owns computer programs he describes as having artificial intelligence, AI, capable of generating original pieces of visual art akin to the output of a human artist. One such AI system, the so-called Creativity Machine, produced the work at issue here, titled A Recent Entrance to Paradise. Right now. A Recent Entrance to Paradise. There we go. Generated by a generative AI art system. After its creation, plaintiff attempted to register this work with the Copyright Office. In his application, he identified the author as the Creativity Machine and explained the work had been autonomously created by a computer algorithm running on a machine, but that the plaintiff sought to claim the copyright of the computer-generated work himself as a work for hire to the owner of the Creativity Machine. Now, this is an interesting argument. Work for hire means, typically, the typical situation you see work for hire is a company hires an employee to make something. An example, like somebody like Disney hires somebody to write a song for their musical, but they do not want that person to own the rights to it. They don't want to keep paying that person a license for it, so they say, we're going to pay you to make it, we get all of it. Now, Thaler is saying that in this case, his AI system that he developed is essentially kind of that same employee agency relationship or directive, where he is telling it what to do and it's giving it to him, and so he's trying to get the copyright in that way, which is a little bit sneaky, but also it doesn't seem to pan out too much here. See, so the Copyright Office denied the application on the basis that the work lacked the human authorship necessary to support a copyright claim, noting that copyright law only extends to works created by human beings. That's what we've been hearing over and over again. The Copyright Office continually says only human beings can produce copyrightable works. Alright, so let's get just jumping down to the discussion here, and we'll see what the DC Circuit Court has to say. Under the Copyright Act of 1976, copyright protection attaches immediately upon the creation of original works of authorship fixed in any tangible medium of expression, provided those works meet certain requirements. A copyright claimant can also register the work with the Register of Copyrights. Ugh. Upon concluding that the work is indeed copyrightable, the Register will issue a certificate of registration which, among other advantages, allows the claimant to pursue infringement claims in court. A valid copyright exists upon a qualifying work creation and apart from registration. However, a certificate of registration merely confirms that the copyright has existed all along. Conversely, if the Register denies an application for registration, for lack of copyrightable subject matter and did not err in doing so, then the work at issue was never subject to copyright protection at all. So that's what this is all about. That's why Thaler is suing, is this was rejected by the Copyright Office as not copyrightable because of the AI system that produced it. And so Thaler is now suing because their refusal to register it means that it was not subject to copyright protection at all. And basically, I can show you this. I can show you this image all day long. I am not going to because I'm also still using it under fair use just to be safe. You know, gotta keep all of your bases, right? If you have them, I suppose. In considering plaintiff's copyright registration application as to a recent entrance to paradise, the Register concluded that this particular work will not support a claim to copyright because the work lacked human authorship, and thus no copyright existed in the first instance. By design, in plaintiff's framing of the registration application, then, the single legal question presented here is whether a work generated autonomously by a computer falls under the protection of copyright law upon its creation. This is what we've been talking about all day. Can generative AI works be produced? Can AI-generated works be copyrightable? And in and of themselves, no, is the short answer. But as we've discussed, it's a little bit more complicated than that once you get to arrangement and other things. Plaintiff attempts to complicate the issues presented by devoting a substantial portion of his briefing to the viability of various legal theories under which a copyright in the computer's work would transfer to him as the computer's owner. For example, by operation of common law property principles or the work for hire doctrine, which, as we just described, is a computer your employee. Are you hiring a computer to work for you when you use it, or an AI software? Are you hiring it to work for you when you give it a prompt? I would lean to no. I think most people would say no, and Copyright Office says no, and the court's not going to buy these arguments either. These arguments concern to whom a valid copyright should have been registered, and in doing so put the cart before the horse. By denying registration, the Register concluded that no valid copyright had ever existed in a work generated absent human involvement, leaving nothing at all to register, and thus no question as to whom that registration belonged. Now, it's a little footnote. I'm not going to skip over this footnote because there's a little bit, well, we'll see here, how the court is viewing Mr. Thaler's arguments, how the court is viewing these plaintiffs' arguments here. In pursuing these arguments, plaintiff elaborates on his development, use, ownership, and prompting of the AI-generating software in the so-called creativity machine, remember his product, implying a level of human involvement in this case entirely absent in the administrative record. As detailed in Part 1, plaintiff consistently represented to the Register that the AI system generated the work autonomously and that he played no role in its creation, and judicial review of the Register's final decision must be based on those same facts. So, he spent a lot of time talking about how he made the AI system, how he created this software to do this on its own. And the court is saying that that's not enough. That he also is saying that he played no role in the creation of the work. And so that's the level of what it is. He gave the decision-making of the creative work to the AI, and there might be other protections involved there for the software itself. There might be other ways that he could get intellectual property protection there if he wanted to go those routes, but getting copyright protection for these generative AI works is not going to happen for him in this case. But let's see what they say here. Plaintiff correctly observes that throughout its long history, copyright law has proven malleable enough to cover works created with or involving technologies developed long after traditional media of writings memorialized on paper. In fact, that malleability is explicitly baked into the modern incarnation of the Copyright Act, which provides that copyright attaches to original works of authorship fixed in any tangible medium of expression now known or later developed. So they're taking the next little chunk of text here from Section 102 of the Copyright Act, and they're saying we've already kind of anticipated this, but underlying that adaptability, however, has been a consistent understanding that human creativity is the sine qua non at core copyrightability, even as that human creativity is channeled through new tools or into new media. So, new technology versus new forms of human creative expression is what they're getting at here. New ways of humans expressing themselves, which are anticipated as copyrightable. So a camera may generate only a mechanical reproduction of a scene, but does so only after the photographer develops a mental conception of the photograph, which is given in its final form by that photographer's decisions, like posing the subject in front of the camera, selecting and arranging the costume, draperies, and other various accessories in said photograph, arranging the subject so as to present graceful outlines, arranging and disposing the light and shade. It goes on here for a little bit about crafting the overall image. And that's something that the court is saying is still allowed. This is something that they're hinting towards artists, it seems, as what is copyrightable. What will you be able to use to get copyright protection? And as long as you have this sufficient level of arrangement, then you will get protection. But here's what the court says about the human authorship requirement. Copyright has never stretched so far, however, as to protect works generated by new forms of technology operating absent any guiding human hand, as plaintiff urges here. Human authorship is a bedrock requirement of copyright. And that's what we've seen over and over again today. So it's clear as day as to what is not allowed. But remember that there's plenty more here. And this actually goes over the Urantia case as well. It talks about the celestial beings. And here, let's read this a little bit more. So the Urantia case, you might remember that we talked about earlier today, is the Ninth Circuit case where celestial beings were conceded to be the authors by both parties. Neither party claimed ownership. And still, they were able to obtain copyright protection over the arrangement of the message, let's say, the content provided by the celestial being, as they both were. So they were able to obtain copyright protection in that way. Now, let's just wrap this case up here, because we do know where it's been heading this whole time. For the foregoing reasons, the Copyright Office is correct, essentially, is what it's saying, as the defendants, and that they acted properly in denying the copyright registration for a work absent any human involvement. Now, keep in mind what they're focusing on here, the standard is the human involvement. It's not the generative AI involvement. It's not the fact that you used it at all. It's not the fact that you used it for some or part or however many steps out of it. It's that you had human involvement to begin with. And describing that to the Copyright Office when you seek copyright protection for your work is going to make obtaining that protection through registration all that much easier. I think that's all that I have for you today. Thank you for listening to me, and we will be back soon.